here, and we send their regards. But we are very lucky to have here Una Fitzgerald, who is the president of the Canadian chapter of the International Law Association. The group is sponsoring or co-sponsoring tonight's event. And I think without any further ado, I would introduce our panel and our panelists. The idea is, and we'll double check whether we are recording in a second, but to have the presentations recorded so that we can then share it with those who cannot make it today. But stop the recording then at the Q&A, so feels at ease to ask questions as well. But let me start by introducing our three panelists here. So the topic, as you see, military action with consent. This is based on a report or interim report by a working group of the International Law Association. And so I'll introduce our three speakers here, starting with Professor Hannah Woolaver, who's an associate professor of public international law at the University of Cape Town. She has a PhD in international law from the University of Cambridge and has also a visiting professorship there at the Lauterbach Center. And she is the co-chair of the International Law Association's Committee on the Use of Force, Military Action with Consent, the topic of today's session. Next, we have Mary Ellen Tran, who is the Robert and Marion Short Professor in the School of Law and also Professor of International Peace Studies at the Keck School of Global Affairs of the University of Notre Dame. She is a very well-known and very distinguished scholar with many accomplishments and many degrees. I will only maybe list a few here. She was at the Global Commission on Responsible AI in the Military Domain, named by the Netherlands in 2023. She has also a link to the Lauterbach Center in Cambridge, having given the Hirsch Lauterbach Memorial Lecture at the University of Cambridge. And she has spent some time in Germany, my country of birth, at the European Center for Security Studies in Germany. And as I was cutting onions this weekend, and I was listening to The Economist, I saw her quoted this week's edition. All right, and last but not least, Professor Brett R. Roth, who is a professor of political science and law at Wayne State University in Detroit. So in a sense, coming to us from not as far away, but having arrived late last night or this morning, nevertheless. Professor Roth has a JD from Harvard University and a study at Columbia University and a PhD from the University of Berkeley, California. And he has published widely in international law, including on sovereign equality and moral disagreement, most recently with Oxford University Press. All right, without any further ado, I would now give the floor to our speakers. What we'll do is that Professor Woolaver is going to speak a little bit about the work of the committee, and then we will pass to Professor Roth, Woolaver, and so the floor is yours.
Okay, thank you so much, Wolfgang, and thank you to the ILA Canada for hosting us here today as well. It's lovely to be here, despite the time of year in Ottawa. So let me begin by briefly introducing the work that our committee has been undertaking on military action with consent, a topic that has become increasingly central to the modern jus ad bellum. As many of you will know, consent has become one of the most frequently invoked bases for contemporary cross-border force. It's been cited in contexts as varied as France's operations in Mali, the US-led coalition in Iraq, the Saudi-led intervention in Yemen, the Southern African Development Community's intervention in Mozambique, and Russian and Iranian support for the Assad government in Syria. At the same time, Russia's invocation of consent for its actions in Ukraine stands as a stark example of how consent can be manipulated or asserted in ways that undermine the foundations of the jus ad bellum, the law on the use of force. So this landscape reveals a doctrine that is, on the one hand, central to state practice, but on the other hand, whose legal boundaries remain deeply contested. So over the last several years, our committee, the International Law Association Committee on the Use of Force, military action with consent, has been tasked with providing a comprehensive clarification of the international law governing situations in which one state undertakes military action on the territory of another state with the territorial state's consent. And we aim to bring clarity and doctrinal rigor to an area where practice is extensive, but the legal framework has remained challenging and at times unsettled. The committee was established in 2018 as a successor to previous iterations of the ILA's Use of Force Committee. And this version of the committee began its operations really in earnest in 2020. Unsurprisingly, then we suffered from pretty significant COVID-related delays, and our mandate was extended to 2026. So we aim to present our final report at the ILA Biennial Conference in Vienna next year in 2026. So why this topic of military action with consent? Well, consent-based military operations have grown dramatically in scope and complexity. They now include not only deployments of ground troops, but also drone strikes, counterterrorism operations, protection of nationals missions, and actions undertaken under status of forces agreements and other stationing arrangements as well. At the same time, many such interventions take place in legally and politically sensitive environments, contested governments, internal unrest, or ongoing armed conflicts, non-international or international armed conflicts. And as our committee notes, although the core idea that a state may consent to foreign military action is well accepted, that simple starting point is deceptive. And it raises difficult questions about who may consent, in what form consent must be given, under what conditions, and subject to what limits. So the first task for our committee was to set out to clarify the scope of our topic. And rather than using other, perhaps more commonly used ways, such as intervention by invitation or military assistance on request, terms that we consider to be perhaps too narrow or in fact sometimes even misleading, we settled on the more precise term military action consent. And we in fact changed our name from the Committee on Military Assistance with Request to Military Action with Consent after a fairly long debate within the committee on that topic. Yeah. So this term emphasizes what is legally decisive in these scenarios, the issuance of valid consent by the territorial state. And it also reflects the full range of contemporary practice that we aim to examine, rather than merely forcible assistance to the government. So secondly, we analyzed where consent-based action fits within the wider international legal framework. And I'm thinking Mary Ellen might jump in on this a bit later, but our committee's work confirms the longstanding view, grounded in jurisprudence and state practice, that valid consent provides the legal basis for foreign military action that would otherwise violate Article 2.4 of the UN Charter and the customary international law prohibition of the use of force. Our final report, to be presented next year, supports the position that where such valid consent exists, the prohibition of the use of force is not engaged. That is, Article 2.4 of the UN Charter and the customary prohibition of the use of force do not apply to military action with consent, rather than it operating as a third exception to the prohibition alongside self-defense or Security Council authorization. And this reflects the dominant understanding and scholarship and also the earlier work of the ILA Committee on the Use of Force. At the same time, we distinguish military action with consent from related concepts such as collective self-defense, humanitarian relief operations, and peacekeeping. So while these sometimes overlap in practice, each operates according to different legal criteria. And one of the aims of our committee is to help ensure that these categories are not inadvertently conflated. Third, a substantial part of our work has examined what counts as valid consent. We address several core questions here. So first, who may consent on behalf of the state? We analyze the authority of governments, contested authority situations, and the role of recognition, all of which can be highly complex in modern conflicts. And this also involves questions of whether a government engaged in an internal conflict, or especially in a non-international armed conflict or civil war, may consent to foreign military action, or if there's a rule restricting undemocratic governments from issuing consent. And these are issues that Professor Roth will look at in detail. We look at when consent must be given. So we confirm that consent must precede the use of force, and we examine the status of anticipatory consent, especially in so-called intervention treaties, such as the Pact of the African Union, and whether there is a requirement of contemporaneous confirmation in the case of such treaty-based consent. We look at the form in which consent must be expressed and conclude that it can be written, oral, public, or non-public, but in all cases, it must be clearly established. Implied consent is possible, but requires close scrutiny and carries a heightened risk of abuse. We also look at the parameters of consent in terms of the territorial state being able to limit the duration, geography, operational scope, and permissible targets, and the fact that the acting state is strictly bound by these limits. We also look at the withdrawal of consent and what, if any, procedural requirements apply to the territorial state's termination of its consent for military action. Beyond that, our work acknowledges other bodies of international law that continue to apply fully in the execution of these consensual operations. These include the right to self-determination, Security Council decisions, international humanitarian law, international human rights law, international criminal law, and of course, responsibility of states when assistance contributes to internationally wrongful acts. Finally, we address questions of the burden of proof and also the legal consequences of action without or beyond consent, including responsibility for violations of Article 2, subsection 4 of the UN Charter. So, to sum up, the committee's project aims to offer a comprehensive framework for understanding and evaluating military action with consent. And our goal is to bring increased precision, clarity, and conceptual coherence to an area that is central to contemporary practice, but is often legally under-theorized. So I hope this gives a helpful overview of the work of our committee, and I look forward to discussing how these principles illuminate the broader work that we'll present in the rest of the panel.
Well, it's great to be here in Canada giving this talk. I can see Canada out my window, as Chris knows, from across the river in Windsor in downtown Detroit. And I look across the river and think of the land of peace, order, and good government. And particularly with particular nostalgia, at this moment in my country's unfortunate circumstances. It's a great honor to be on the committee. I've succeeded to this committee from a previous ILA committee on recognition and non-recognition of states and governments. And it is that background that I bring to bear on these kinds of questions. And so there are a number of contested issues about military action with consent, as to which there are not clear majority and minority views in the literature overall. There are majority and minority views within the committee. But I want to speak specifically to this one question, which you see in the handout, which is, does civil war vitiate an established government's legal capacity to consent to intervention? This is a particularly vexing question, and it goes to a doctrine or proposed doctrine that's become known as negative equality. And so I want to speak a little bit to what the basic logic of that is. But in order to do that, I think I need to set the stage by saying something about the overall conceptual framework in which it fits, and particularly the assumptions of earlier periods, particularly the Cold War era, that permeated many of the doctrinal developments. And the question that arises largely in the 21st century is how relevant many of those underlying assumptions are. But I think if you look at the UN Charter order, particularly as it developed through the two generations following the promulgation of the Charter, what you find is international law serving as a framework of accommodation among different interests and different values in the international system and different levels of power and influence and certainly different perspectives, especially coming from the three blocks of the Cold War era, the Eastern Bloc, the Western Bloc, and the Southern Bloc, which combined to produce a great deal of proclamation about international law and the operation of the international order in ways that represented certain kinds of compromises, some of them quite obscure because different groups could use the same language to mean very different things based upon very different sets of normative premises about the nature of justice, the nature of legitimacy, the nature even of legality. So if you understand the international system as attempting to provide a framework of peace and cooperation among people who have fundamental disagreements, then you can see a certain kind of logic. States in this system need to be understood as legal categories. A state isn't a thing like a table is a thing. A state is best understood as a package of rights, obligations, powers, and immunities. And states are conceptualized in the international system as manifestations of the self-determination of their territorial populations. That comes through in various aspects of the UN Charter and the preamble in Article 1, Paragraph 2, but particularly as developed in other articulations, particularly of the UN General Assembly, and above all, what's called the Friendly Relations Declaration, or what I like to call the Grudging Accommodation Declaration of 1970. This is not about people sitting around holding hands singing Kumbaya. This is about how people who have fundamental conflicts nonetheless have a basis for interacting with one another. But the understanding is that states represent their territorial populations and have this package of rights, obligations, powers, and immunities that are unique to statehood. And then the problem is who can assert rights, incur obligations, confer immunities, exercise powers on behalf of that underlying sovereign entity. And that is what we call the government. If the government is understood as acting in service of this project, then we have to understand the government as somehow being authorized by the underlying population. And how does that work, particularly in a period when what we think of as free and fair elections were not really the norm? And so historically, and actually over a period of centuries, the doctrine emerged that the government was to be understood as deriving its authority based on the idea of effective control through internal processes. And effective control really has to do not so much with the ability to impose upon people, but rather the flip side of that, the popular acquiescence in a particular political order. And that popular acquiescence is understood as a sufficient act of will on the part of the population to say effectively that the government represents the state for international purposes. The idea being that however tyrannical the ruling apparatus and effective control might be, there's no reason to think that foreign states are going to come and rescue you. Rather, foreign states might be interested in taking advantage of conflict within your state in order to engage in predation against your political community as a whole. And so the notion was essentially that governments that were in effective control could be understood as representing the underlying population provisionally for the set of purposes associated with the operation of international legal norms. And so this then gives rise to a fundamental problem when it comes to the question of consent to foreign forces being used on the territory. Because what happens when effective control is compromised? What happens when there is a sufficient dissipation of effective control on the part of the government, where there is a kind of response to governmental authority that is sufficiently non-compliant as to give rise to a major challenge to that government's effective control coming through in internal processes. A kind of corollary of what I have sketched out is that the capacity of the government, having been drawn from the ability to exercise effective control, is vitiated by its incapacity. The very fact that it would, for example, need to invite in foreign troops into the territory to secure its power would seem to refute the proposition that the government actually represents the underlying population for this purpose. So a kind of quintessential example would be the Soviet invasion of Afghanistan. We always call it that, right? The Soviet Union claims to have been invited into Afghanistan. The old joke about this was, why are the Soviets in Afghanistan for so long without looking for the people who invited them? Now, it turns out that the actual invitation itself was likely inauthentic. But the reason for the international reaction to the Soviet intervention in Afghanistan was not really the quibble over the authenticity of the invitation by one or another communist faction that held power in Kabul. It was the fact that the country was experiencing an uprising against the communist government. The communist government needed Soviet troops in order to keep itself in power. And that itself undermined the foundations for this legitimacy of the intervention. And the international community overwhelmingly regarded the Soviet presence in Afghanistan as illegal during this period. So the question that arises is whether this concept of negative equality, the idea that if there is a civil war within a state, that you shouldn't be able to intervene on either side, is something that continues to have vitality. First of all, was it a real norm of the international system in the first place, or just a kind of prudential proposition put forward as lex ferenda by various legal scholars? If it was a norm, is it still a norm? And particularly, does an emergent democratic norm in the international system change the situation because free and fair elections and mandates derived from free and fair elections can be seen as a better substitute, as a proxy for popular will than patterns of popular acquiescence? And so that's really where the action is on this topic. I've laid out for you a number of provisions that give you some flavor of how these issues fit together. The Friendly Relations Declaration, very strong on the proposition of non-intervention in the internal affairs of states as a kind of corollary to the self-determination of people. And indeed, it was countries emerging from colonialism and neo-colonial domination that were most concerned with the idea that once statehood had been achieved, that it could pursue their self-determination, that they had an inalienable right to choose their political, economic, social, and cultural systems without interference in any form by another state. The sort of negative equality corollary to this can be perceived in certain articulations, including the line about interference in civil strife in the Friendly Relations Declaration. But this has some pedigree going back to an inter-American treaty in 1929 on civil strife, which talked about the circumstances in which there would be a foreign intervention where only the government would be able to invite assistance from abroad, except where the rebel force was recognized as having the status of belligerent. And where there is a recognition of belligerency, there would be a rule of neutrality. There's a long history to all of this, which I don't have time to get into right now. But one thing to note about this historically is a tripartite distinction among challenges to governmental authority of rebellion, insurgency, and belligerency. And it is unclear whether belligerency is simply a matter of recognition or whether it's an objective matter, whether that's changed over time. It's also originally when this idea was hatched, there was not the same norm against the use of force as there is presently. So exactly how this carries forward is unclear. But the notion has carried forward, and particularly most famously is embodied in a resolution of the International, what's called the Institut de Droit International, IDI, in 1975, which asserted this principle of negative equality, that where there is a civil war, that there can't be this intervention. And the best interpretation, although it's murky in this, that civil war would attach to the idea of belligerency. And that should be, I think, distinguished from merely the existence of a non-international armed conflict where the law of armed conflict applies. That might apply to the word insurgency rather than belligerency, where belligerency entails control over territory and a much greater capacity to challenge governmental authority at the core on the part of the forces that are contesting for power. There is a lack of clear practice on this question, and part of the reason for the lack of clear practice is that states that have intervened on the side of a government have typically done so where they have been able to assert, plausibly or not, that what they're doing is counter-intervening. They have not been so much contesting the idea of negative equality as they have been invoking an exception to the principle of negative equality, where if the insurgent forces are being supplied from abroad unlawfully, that the government then can call upon its allies to counter-intervene against that. And the problem is that since the government has been able to import weapons without limitation prior to this golden moment of the achievement of sufficient critical mass on the part of the opposition to represent belligerency, it might almost be inevitable that there would be unlawful interference in terms of an arms flow and so forth to the insurgent forces in order to make them a viable challenger. In that sense, the negative equality doctrine has something, the seeds of its own destruction. Nonetheless, it could still be argued that this is the default position and that it's important. Well, I'll just very briefly, because I've really run out of time, say something about the idea of the democratic norm. The turn of the 1990s created, both to some extent in international organizations and in international legal scholarship, a new emphasis on the right to political participation and its relationship to political authority, going back to this old idea that is at a high level of abstraction, completely supported in the international community, but not necessarily concretized, that the will of the people should be the basis of the authority of government. If democracy becomes now the touchstone, this has a major impact on this idea of the government and effective control representing the will of the people. We now perhaps have a better manifestation of the will of the people in the mandate conferred by free and fair elections. And I want to introduce a note of caution about this, which I do at the end of the outline here, that democracy is a much more elusive idea than people often give it credit for in this literature. That democracy has long been characterized as what's called an essentially contested concept. And that what can be said about this is that procedural solutions, which are associated with democracy, are typically abandoned by people who think that the essence of democracy is substantive, and that an acute or chronic failure to fulfill the expectations of democratic procedures in terms of the actual substance of a democratic society, when these things have failed, people abandon their fidelity to those procedures. And I think it's important to recognize that sort of demarcating the moral high ground in civil conflicts based upon these procedural solutions alone is a highly dangerous thing to do. We can talk about circumstances in which people have tried to do that and how this might fit with actual practice later on. But thank you for your time.
Great. Over to me.
Review.
Anyway. Shouldn't we just all present our comments? What were you going to say?
Yeah,
I'm ready to jump in.
yes, then I'll put on your.
Thank you.
slide.
That would be great. That's not the first one.
You have to just.
Oh, right.
Backwards.
There we go. I am very happy to be here also. My grandfather was an economic migrant from St. John, Newfoundland in around 1910. And so otherwise I would be Canadian also. And it's always in my mind how we treat the migrants, since all of my family either came from Canada or Ireland, seeking a better life and seeking peace. If we're going to be serious about peace in this world at this heightened time of incredibly widespread violence in all kinds of different contexts, if we're serious about supporting a robust law of peace, a robust prohibition on the use of force, we have to take seriously this problem that Hannah and Brad have already described of military assistance with consent, the use of military force on another state's territory on the basis of consent. It is, as Hannah already explained, the least well theorized of the three usual justifications. They're usually termed justifications. In my theoretical world, I'd rather talk about the three limits on the scope of the Article 2.4 prohibition. All three of them are part of a body of rules known since ancient times, and we inherit these rules with this ancient wisdom, with this constant understanding through the generations of having something we call the jus ad bellum, the law regulating resort to force. It has a core rule, one very distinctive and important rule: the prohibition on the use of force. This is where it starts. This is as old as any human interaction with another person, that we have a choice. We can beat them up, or we can respect their right and look for alternative ways to resolve disputes. So that's what the rule of law anthropologically, historically has been, to prohibit force. And the prohibition on the use of force is speaking to the worst kind of force, organized armed force. And it has always been considered to have limitations for self-defense, when authorized by a body with authority, today that is only the UN Security Council, and for when there is consent, an invitation to assist in a lawful goal by another party with authority to make that invitation. That's the prohibition and the three limitations. In any one of those limitations, for those limitations to be lawful, there must also be respect for the principles of proportionality and necessity. Proportionality and necessity are as old as the prohibition on the use of force itself, and characterize every forceful action that we humans take. So in international law, in all of law, those of you who study criminal law, you know that criminal penalties, prison terms, and so other kinds of penalties must always be proportionate to the crime. This is just a general principle of law that we get on the basis of natural law, because it must be part of law. It is inherent in the law. We identify it that way. We don't make it up, pass statutes about the proportional nature of criminal sentencing. It's the same with these two principles of necessity and proportionality. They condition how any lawful, forceful action is used. So we're talking about the use of military force from the rules on the jus ad bellum, but there are also principles of necessity and proportionality conditioning how the use of force is used in the conduct of armed conflict. So in international humanitarian law or the use in bello, we also pay careful attention to necessity and proportionality. The third big category in international law, where we look to necessity and proportionality, is coercion and forceful action short of armed force. And that's particularly in the area of countermeasures, known more commonly, of course, as sanctions. So sanctions or countermeasures are also conditioned if you have a just cause to use them, a prior violation of international law. You must carefully calibrate your forceful action to what is necessary and proportionate to reinstate the lawful situation. So these are, as I said again, not principles of customary international law. They're not principles of treaty law. Nevertheless, as of now, these two principles, which in my long study of the jus ad bellum are always part of conditioning any lawful resort to force, will not appear in our report. My understanding is that there is an objection that these are not relevant to regulating when force is used with the consent of or at the invitation of a state that is responding to a forceful action on their territory. It's been difficult for me to respond to this particular objection. Every paper I've ever written on the prohibition of the use of force always includes necessity and proportionality. And I've never seen a developed argument against using these principles for all three of the justification for not complying with the prohibition on the use of force. But I think I can try to answer some of what may be the concerns that have come out in some of the discussions. But first, let's have some definitions. So the International Court of Justice has made it clear, well, we're in Canada, so I have to start with the first reference to, first written reference to necessity and proportionality that every student of international law hears about, and that's in connection to the Caroline case. And is everyone here familiar with the famous case? So in the 1830s, when there was still some hope by some militants in the United States, non-state actor armed groups operating on the US side of the border, that they could create a revolution in Canada, rise up against the British, and become part of the United States. That would have been great. I know you've heard of a similar plan in recent years, but they were taking active steps to try to arm the militants. There were some sympathetic people on the Canadian side, and so they were working together, and the US side was delivering weapons on a ship called the Caroline. And the British government decided to put an end to this. So they sent a group of troops. One of your professors here at Ottawa, Craig Forsessi, has written a fabulous book with lots of details on this incident. So I'll keep it short. They lit the ship on fire, despite the fact there were 33 people on board. About 24 of them got off. There were about another 9 or 12 that were unaccounted for, and the ship was sent over Niagara Falls. One of the people who was involved in the raid from the Canadian side, together with the Canadian forces, was arrested 4 years later in Buffalo, New York, for having participated in this action. And then a famous correspondence went back and forth between the British government and the US government. And the important words, and for our purposes, what we really take away is this wonderful definition of both necessity and proportionality that must always condition any forceful action. So the US side says that they're very happy that both sides agree, the US and the British agree, that respect for the inviolable character of the territory of independent states is the most essential principle of civilization. While it is admitted that exceptions growing out of the great law of self-defense do exist, those exceptions should be confined to cases in which the necessity of that self-defense is instant, overwhelming, and leaving no choice of means and no moment for deliberation. Real necessity. And in an earlier letter to the British authorities, US Secretary of State Webster included a requirement of proportionality. He said, it will be for Her Majesty's government to show also that the local authorities of Canada, even supposing the necessity of the moment authorized them to enter the territories of the US at all, did nothing unreasonable or excessive, since the act justified by the necessity of self-defense must be limited by that necessity and kept clearly within it. The International Court of Justice has made similar descriptions of necessity and proportionality. In the Nicaragua case, a very famous case on use of force by the US on the territory of Nicaragua, the court said the US lacked a basis in self-defense from the UN Charter. It lacks any justification for self-defense, and therefore it fails. But even if there was an invitation, even if there was justification for using force on behalf of El Salvador or someone else, that force has to be necessary and proportionate. And the significant thing about the ICJ's decision in Nicaragua and in 2 or 3 other cases, necessity and proportionality are not in the UN Charter. Article 2, paragraph 4 was codified from this ancient law we have from the great theorist Kellison. He says, Article 2.4, the UN Charter is codifying the natural law, just war doctrine, prohibition on the use of force. But they do not spell out, and the original draft of the UN Charter was changed at the last minute, has no reference to self-defense, that's added later in Article 51, and no reference to justification on the basis of an invitation or consent, nor does it include necessity or proportionality. But the court says necessity and proportionality predate the Charter. It's from this ancient law, and you must meet those 2 terms too, even if you start out with a lawful basis. In fact, I have found in my diligent research since hearing from members of the committee that they did not want to include necessity and proportionality in our report. When I heard this last February, I have found no authority that even hints necessity and proportionality do not apply to all forms of force and coercion. So what these principles do, regardless of the type of forceful action being carried out, is to provide procedural guideposts to limit the amount of force or coercion used, even in a case of lawful resort. Using coercion is always a deviation from the normal situation, justifiable in exigent circumstances only. The principle of necessity restricts force and coercion to cases of last resort and when force has a reasonable chance of accomplishing the lawful objective. Those are the 2 meanings of necessity, summarized, you can tell, in the case of the Caroline. If the use of force or coercion meets this necessity test, the 2-pronged test, last resort, chance of success. We get this all from the ancient just war doctrine. It is part of contemporary law. Then the proportionality principle must be met. We rarely get to proportionality in these discussions because it's almost never the case that a state has both a lawful basis for resort to force, a justification in self-defense, Security Council authorization or invitation, and that they can also meet necessity. Almost never happens. But if in the rare case that it does, then proportionality asks whether the coercive measure is roughly equivalent to the law violation to which it responds, or is it outweighed by the cost in terms of loss, destruction, or death. Those of you who work on trade law, you know that the World Trade Organization Dispute Settlement Body regularly has talked about this principle of proportionality, drawing on the Air Services case, in which the court in air, or the tribunal in air services, that rough equivalent, and that's the injury to the response, and that carries forward in other areas. The International Court of Justice, in its several opinions in which it talks about necessity and proportionality, unfortunately, and a few of them refer to these principles as customary international law. I've been mentioning that they're general principles, that they come from a theory of natural law, as does the prohibition on the use of force itself. The prohibition on the use of force is jus cogens, and I consider the exceptions have to be viewed in light of that, so kept narrow, etc. But the general principles are different. They are also based on natural law, but they are not of this moral kind. They're not a human rights kind, the way the prohibition on genocide and so forth are. They are procedural types of rules that condition other conduct. And therefore, it's better to understand them as general principles from the third primary source of rules from the International Court of Justice. I can confirm this by the plain text of the ICJ statute referring to the primary sources of international law, treaties, custom and general principles. But even more, the negotiating history of the statute of the International Court of Justice reveals that there was a dispute between a few of the common law. It was really just the American Elihu Root in the 1920s when they were drafting, or 1918 to 20, when they were drafting the original statute of the International Court of Justice. He was a strict positivist. He wasn't well trained in international law. He did not like any idea of natural law. He was a modern man. He just thought that he needed control. Treaties were good. Ideas that came through something like natural law, it made no sense to him. Whereas the civil law countries, and really, I think even the British at that time, were saying, no, the idea of general principles, we have to include that as part of a non-positive law basis for regulating law. They endure, they're inherent in law. It's a dispute that's now happening at the International Law Association and their work on general principles. But so there's no reference to natural law in the statute held out by the American Elihu Root, but we've got a really wonderful analysis by Judge Tanaka of the internet when he was writing a long opinion on general principles in dissent from the Southwest Africa cases. And he explains this debate and how the American kept any reference from natural law out of the statute of the court. But he says, of course, it's natural law. So Tanaka was Japanese, and he understood, he had a very wonderful historic sense of where international law came from and what its components really needed to have. And he explains that that the members of the committee who accepted natural law went along with this compromise, but he said that the true nature of general principles are from natural law, meaning they endure and do not change through treaties and customary international law. And he was writing about equality. And he made the very clear and normative comment, you cannot have a legal system that does not have a principle of equality. And if you have a principle that cannot be removed by a treaty or customary international law, it has to rest on a different basis than those two sources. The only remaining basis is natural law. So the main authority on general principles, including their source in natural law, is Bin Chang. He includes necessity in the general principles and therefore rests them on natural law. So that's where these two principles come from. We have to have necessity and proportionality throughout the law to keep it valid law, to make sure that it has the indicia of legality. Now, another member of the committee seems to feel that part of the reason why we should exclude necessity and proportionality from our report is that once the consent has been given, there's no further regulation from international law. We no longer worry about the prohibition on the use of force in a consent-based context in which further regulation from international law is not needed or is irrelevant. I take real issue with that. I understand the problem that there's not an affirmative case that's been made by the court. The court has this unfortunate language about customary international law is only spoken in self-defense cases and not it has said nothing specific about the conditions on when a state can accept consent. But here's the problem. You can have a lawful basis at the start of a use of force, an invitation or consent. And then as time goes on, the necessity and proportionality of using force under that consent changes. So you may have had an initial basis, but unless you're constantly keeping the necessity and proportionality conditions in mind, what was once a lawful use of force is now an unlawful use of force. The assessment of necessity and proportionality, we know this from many judicial decisions, including we have some that do not involve self-defense. The UN Charter itself puts a necessity and proportionality restriction on authorization by the UN Security Council. Old case called Nolila, when armed reprisals were lawful, they require necessity and proportionality. So we have that, but the real work that we can see today, and so that was the other argument, that no one's applying necessity and proportionality to invitation. We have a lot of unlawful use of force going on. If we look at a particular case, we can see how an initial invitation might have provided a basis for legality, but over time, 21 years of time of continuing to use force, then we're no longer at a point where this is lawful. In the case I want to point to you where we can see the value and the importance of article of necessity and proportionality, and the obligation, once necessity and proportionality are no longer being met, we must move to the use of peaceful means, is in the case of Somalia. And I'll be very brief because I know I'm over time. So in Somalia, the United States started using military force in Somalia either late 2006 or early 2007, when it was under something called the transitional the transitional government, the transitional federal government of Somalia. It was very weak, but it at least lasted for about 8 years, unlike the 14 previous attempts to form a government of a lasting kind after the fall of the dictator Siad Barre in 91 with the end of the Cold War. So President Bush began attacking in Somalia because of a group called Al-Shabaab, had loose ties to Al-Qaeda, and he used some of the arguments that Brad referred to, this war on terror, which was a fictional war, and we were killing people without legal basis, as I've written in many, many different articles. President Obama was very uncomfortable with killing people on the basis of, as he said when he was campaigning for president, you cannot have war on a concept. So he tried to find some legal basis, and he and his advisors hit on the idea of invitation. I've never thought that either the transitional government that that lasted until 2012, so first giving was a real government meeting the standards that Brad had spoken to. I would say the same about its successor, which has lasted since 2012, but maybe about to collapse now, the federal government of Somalia. So President Obama said that they gave him an invitation. So this government does hold the seat for Somalia in UN. So we will say that many people would argue that they are the government with the authority to issue the invitation to help in their struggle against Al-Shabaab. Well, the bombing went on and on. President Trump not that concerned with what the legal basis was. At any rate, he carried out 185 bombing strikes on Somalia between in his 4 years as president. President Biden came in, he carried out 48 airstrikes. President Trump has returned, of course, and between working back from January until November of this year, so in 10 months, he's carried out over 70 airstrikes in Somalia. We never talk about this. We're talking about the attacks in the Caribbean and the Pacific. We're talking about a pending invasion of Venezuela. We're talking about US participation in the war in Gaza. We're talking about the failure to support Ukraine. Lots of military force being discussed. What about the 70 strikes killing so many people in Somalia? And here's the point, not meeting the principles of necessity, not meeting the principle of proportionality. Why was the US invited in? To counter an insurgency, al-Shabaab. Today, al-Shabaab is stronger than it was when these attacks began. Today, al-Shabaab holds 30% of Somalia. The transitional, or the FGS, the federal government of Somalia, is in deep turmoil. The president has said in 2021 he was going to carry out a total war on al-Shabaab. Since then, al-Shabaab's fortunes have only increased. So using force in Somalia plainly does not meet necessity and proportionality. So even if the US still has an invitation of some value from transitional government, we are not meeting necessity, we are not meeting proportionality, and that use of force is unlawful.
Much.
Thanks so much. So in addition to my overview of the committee's work, I'm going to speak briefly on the purpose-based approach to the legality of military assistance on request. So as we've heard from Professor Roth already, no, that's no problem. The presumption of the legality of military force undertaken at the request of the territorial state has over time been subject to various challenges, including the negative equality doctrine and the democratic legitimacy doctrine. Brad Roth spoke. Recently, however, this challenge has taken the form of what is called the purpose-based approach. According to this view, certain authors argue that the government may not invite foreign military assistance unless that force is said to pursue certain legitimate purposes. Most prominently, this view has been put forward by Christakis and Benallier, and is also supported in a 2011 resolution of the Institut de Droit International. So while there are certain differences in the writings of those supporting this view, the purpose-based approach, or PBA, is premised on the right of self-determination. Accordingly, a government may not consent to external military assistance that would interfere in an internal conflict on the side of the government. According to the PBA, it is only if the purpose of that military action is not to support the government in such a conflict, but rather to undertake a legitimate purpose, such as counterterrorism, counterintervention, or the rescue of foreign nationals, that the invited use of force is said to be lawful. Thus, according to the PBA, the purpose-based approach, the legality of the foreign military assistance turns not only on the invitation of the government, but also the legitimacy of the purpose for which force. My argument, however, is that the PBA, this based approach, is conceptually flawed, legally unpersuasive, and contemporary state practice. And instead, in my view, international law continues to rest on a presumption that the territorial state may authorize the use of force within its territory, subject to the requirements of valid consent and compliance with other bodies of international law of that force. So I'll make three brief arguments supporting that thesis. I'll very briefly outline the traditional approach to military assistance on request that we've been speaking of. I'll then analyze the purpose-based approach, explaining how it upends the traditional presumption of the legality of military action on request. And then finally, I'll briefly highlight why state practice does not support the purpose-based approach. So as we've been hearing, the traditional view, which is long reflected in doctrine, case law, and institutional practice, is the presumed legality of military action on request of the government of the territorial state. Under this view, consent functions as the decisive factor that removes the military action from the scope of the prohibition of the use of force, rendering lawful what would otherwise be a violation of Article 2.4 and the customary prohibition. So as I've set out in my little outline there, we see repeated assertions in decisions of the International Court of Justice, resolutions of the General Assembly, and of the Security Council of unqualified statements of the government's right to invite military intervention. Particularly the ICJ's decision in the armed activities case indicates that the International Court of Justice did not consider that there was a limitation on the DRC's right to invite military intervention, despite the fact that a civil war was acknowledged to exist at the time of conflict between the DRC and there. So these authorities are silent on any doctrinal condition, the legality of invited military assistance related to the purpose of the force or internal political contestation in terms of the use ad bellum. And it's precisely this absence, this silence, that the purpose-based approach seeks to replace with a more restrictive normative rule. So turning then to the purpose-based approach. As I've mentioned, this doctrine challenges the legality of military assistance on request and argues that the government may not invite foreign military action in its territory if this would amount to foreign intervention in an internal conflict, as this is forbidden by the right of self-determination. Now, the proponents of this approach importantly argue that it represents the lex lata, the law as it stands currently. And they draw support for this by looking at instances of invited military interventions in internal conflicts, arguing that both the requesting and intervening governments often point to a so-called legitimate purpose for which force will be used alongside the request of the government. The PBA shares a common goal with the putative limitations of the negative equality doctrine and the democratic legitimacy doctrine, which is really to prevent foreign military action from propping up a governmental regime against the will of the people, as we've heard. However, the PBA is really distinct from these doctrines in important respects as well. So unlike the democratic legitimacy doctrine, the purpose-based approach does not disqualify or qualify a government from inviting military assistance simply because of its democratic or undemocratic nature. And unlike the negative equality doctrine, it does not tie limitations to the government's right to invite military action to the intensity of conflict. Instead, the threshold for application of the purpose-based approach turns on the internal nature of the conflict, which purpose-based say must be freely determined by the people of the state. So in one sense, then, the PBA is broader than the negative equality doctrine because its limitations apply at all times, whether or not a NIAC, a national armed conflict, or indeed an international armed conflict is underway. In another sense, though, it's narrower than the negative equality doctrine because it does permit certain interventions on behalf of the territorial government, even in a civil war when undertaken for these so-called legitimate purposes. Now, there's some disagreement across the literature in terms of the precise scope of self-determination that applies to the PBA and in terms of what constitutes the internal conflict foreign intervention is prohibited. Taken at its formulation, the PBA seems to conceive of any external military support to the government as forbidden by the right of self-determination if that force is directed against an internal of any kind. And these authors then elaborate on their understanding of self-determination by listing the types of pro-government military action that they consider would be allowed despite an ongoing internal conflict. The two legitimate purposes on which the relevant literature agrees are counterintervention and counterterrorism. So this means that counterterrorism is the main exception, the government's lack of capacity to request foreign military assistance in internal conflicts, because the other counterintervention requires the conflict to be internationalized prior to the pro-government intervention. So what are my main critiques of the purpose-based approach? Well, I put forward three. First, I argue that the relationship between the legal content of the right of self-determination of peoples and the purpose-based approach, and particularly the legitimate purposes espoused by the PBA, is unclear and requires further articulation. Secondly, the seemingly subjective and indeterminate nature of the proposed legitimate purposes militate against their establishment as legal categories that can be relied on. And third, there does not seem to be sufficient state practice in opinio juris to clearly support the status of the purpose-based approach in international law. I'll look at these in just a little bit more detail before I wrap up. So first, in relation to the right of self-determination, the PBA literature doesn't explain who constitutes the people whose will is being protected, nor how that will can be identified. And a fundamental problem, I believe, is that it risks treating virtually any internal opposition as an expression of self-determination that requires protection from the use of bellum. But as our friend and colleague Gregory Fox has argued, the government's invitation may sometimes, in fact, vindicate self-determination. We can think, for instance, of when the government seeks assistance to suppress an attempted minority-supported coup within the territory. It could be argued that that, in fact, vindicates the people's right to self-determination. Secondly, the legitimate purposes, which lie at the heart of the purpose-based approach, are highly subjective and indeterminate. The PBA relies heavily on the purpose as a criterion of legality, but in practice, this is defined almost entirely by the governments of the requesting and acting states. And as Vilkova has noted, this makes it very difficult to conceive of any intervention that would actually be unlawful according to this approach. This is particularly evident in relation to counterterrorism. So Olivier Courtin, for instance, has argued, and I quote, "A terrorist group, especially when it is composed of foreign elements, cannot by definition claim to express the will of all or part of the population of a state. Terrorism is stigmatized as a crime and not as a political struggle or rebellion." However, it's well known that governments regularly label all opposition and insurgent groups as terrorists. And the UN Secretary General, for instance, argued in 2003 that there was a significant problem of the widespread use of the terrorist label, which he called the T word, to describe internal unrest or insurgency. Recent practice of military assistance on request in both Syria and Kazakhstan illustrate disagreements concerning who is an opposition group and who is a terrorist group. So as Christine Gray notes, therefore, the legitimating purpose of counterterrorism carries a significant risk of abuse. And it is also unlikely, therefore, to do much work in terms of discriminating between interventions that do and do not support the right of self-determination. The amorphous definition of terrorism may then create an exception really broad enough to swallow the alleged prohibition of military assistance on request in internal conflicts. Now, this raises a broader concern about the method of analysis of state practice, and particularly the extraction of opinio juris used by authors supporting the PBA. The authors in support of the PBA frequently point to practice where they say states point both to the invitation as well as the so-called legitimate purpose, and say that this therefore shows that their opinio juris shows that both of these are essential to the legality of the use of force. I think, though, that this identification of opinio juris is questionable. When states do offer these legitimate purposes, which they often do not, they may emphasize their motives for deploying force in a foreign territory for many reasons, beyond a belief that it's part of the formal legal justification for force. So states often cite these purposes perhaps for domestic political reasons, to bolster the political legitimacy of the force, or to signal that the foreign force will remain within the limits of the proffered consent, and so to avoid an allegation of an act of aggression. So third and finally, I argue that the practice does not appear to support the broad prohibition of military assistance proposed by the PBA. And in fact, I argue that the recent practice appears to support the continuation of the government's right to invite military action on its territory, despite facing internal civil strife, whether above or below the threshold of the civil war. So recent examples that we can point to include military action in Iraq in 2014, Bahrain in 2011, I think I put 2021 on the handout. I meant 2011, Mozambique in 2021, and others as well. And these instances of practice show that even when a so-called legitimate purpose was available to the requesting and acting state, these are not regularly invoked as part of the legal justification for consent-based military action in ongoing internal conflicts. And these instances were widely accepted as lawful purely on the basis of the territorial state's consent. So to conclude, I argue that the PBA is not yet established as a rule of custom, and that there are certain conceptual shortcomings that make its adoption as a rule of custom to be unlikely in the future. And therefore, the government's authority to request the provision of foreign military action in its territory appears still to be presumed in this respect. Now, importantly, this does not mean that territorial governments and acting states are given carte blanche to intervene in civil law. The ICJ has made clear that conditions as to the valid scope of consent must be requested and respected. And we note that there are frequently questions as to the identity of the government that can give lawful and valid consent. Just as importantly, though, the legality of such military action on request is not merely a question for the use ad bellum. Any military action with consent must also comply with rules governing the conduct of force, including rules of international criminal law, international humanitarian law, international human rights law, and indeed the right of self-determination itself. So the non-existence of the PBA and customary international law, I argue, does not result in an unrestricted right to intervene in. So thanks very much for your attention, and I think we're all looking forward to hopefully a little bit of time for discussion.
Thank you very much. Let's first thank the three speakers.